Hello everyone, a very warm welcome to the plea webinar on amendments to the Specific Relief Act. Our guest for today is Senior Advocate Birendra Saraf sir. Sir, it is our honor to have you and we welcome you to the plea platform.
When I use the word occupant, the word occupant is not used in section 6. What it uses what the original section 6 used the word where a suit by a person dispossessed. So if any person is dispossessed without his consent. So there was initially a controversy that possession is equivalent to the person who is physically in possession of the property. So if there is a tenant staying in a property, then it is the tenant who's in possession and not the landlord. So there were cases where a tenant was forcibly thrown out by a third party, but the property belonged to the landlord. And when the landlord filed a suit under Section 6, a defense was taken that, well, the landlord was not in possession. So the landlord had no cause of action to file a suit under Section 6. The landlord suit was supposed to be a suit for title. But the Supreme Court had, over a period of time, in various judgments, which are now set out in paragraph 12 of my note, which you will find, there the Supreme Court set out that the possession here does not only mean the physical possession, but it means juridical possession. So even if a person who has the juridical possession and who has authorized another person to get into these premises or to stay in these premises, that person is also, that juridical possession can also be protected under Section 6 of the Specific Relief Act. Now, the amendment to the Section 6 is to bring about this aspect which the Supreme Court had already ruled earlier. Now, it says, therefore, now that if any person is dispossessed without his consent of immovable property, otherwise than in due course of law, he or any person through whom he has been in possession or any person claiming through him. So now what I've done is these words in green are the words which are added by the Amendment Act. So therefore, it helps to see that now not only the person who was actually in physical possession, but also a person through whom he has been in possession can file a suit under Section 6. So now statutory recognition of an interpretation of the Supreme Court. So therefore, suppose there is a landlord and he has given his premises to a tenant to occupy. So the landlord is not in physical possession of the property, but he has a juridical possession of the property. The tenant is in physical possession. Now suppose a third party comes and dispossesses the tenant. Still the landlord, being a person through whom the tenant was in possession, can file a suit under Section 6 of the Specific Relief Act. So this is the main aspect of Section 6 and the amendment to that. The case laws, as I said, no point I giving you all citations. This is all there in this note. You all can use it. The next amendment, which I will share with you all, the next amendment is the amendment to Section 10 of the Specific Relief Act. Now, Section 10 of the Specific Relief Act were cases in which specific performance of contracts would be enforceable. So there were certain categories of cases where it was provided that specific relief could be granted, and there were certain situations where it was stated that it could not be granted. Now, one of the main important difference is that earlier it said that the specific performance of any contract may, in the discretion of the court, be enforced. So there were the words may in the discretion of the court. Let me just show you all the provisions, then it will become, of course, much easier. Now, if you see Section 10, this is the wording of Section 10. The green portion is added and the red, which is struck off, is the portion which is deleted. This way of reading an amendment really helps because it immediately gives you an idea of what was removed and what has been added instead of having those footnotes in a regular bare act. So see, earlier wording, the opening part was, except as provided in this chapter, the specific performance of any contract may, in the discretion of the court, be enforced. Okay, these are the certain situations. Now just see above, in the green portion, the substitution. The specific performance of a contract shall be enforced by the court subject to the provisions of certain other provision of the act. So therefore, the there is a substitution of the words may in the discretion of the court be enforced with the words shall be enforced. So the discretionary power of the court, whether to grant specific relief or not grant specific relief, is taken away, and a right has been vested where the court shall grant a specific performance. Now, if you see some of these deleted subclauses, it is very helpful because earlier, where damages could be granted, where damages was found to be of adequate remedy, then specific performance could not be granted. So very often, say you had given a, say, agreed to purchase goods, and the other party refused to give you the goods, then you could not enforce that contract, because at the highest you could go and buy it from somewhere else and take the difference from him in the nature of damages. So the principle was that whatever can be compensated in damages which can be ascertained, that cannot be a specific performance of such a contract cannot be granted. And this provision also provided that in relation to immovable property, there was a presumption that money would not be an adequate relief, whereas in case of immovable property, there would be a presumption that money would be an adequate relief, except in certain cases. Say it's a special item of commerce, suppose it's a painting, then you could say that, see, this painting was special to me, where else can I go and buy this, so I can enforce it for that painting. Or say shares of a very, very closely held company which is not available in the market generally. Or if a person was holding certain things, a property, as an agent or trustee. So earlier, the scheme was that where damages could be provided and where damages were an adequate remedy, in those situations, specific performance cannot be granted. Now, if you see the red struck off portion, all these clauses have now been struck off. So the discretion is taken away, irrespective of whether money or damages is an adequate relief or not. These relief, a specific performance has become a matter of right. So all these situations clauses which provided that where money is an adequate relief and where money cannot be asserted, if only money cannot be ascertained that you can give specific relief, have all stood deleted, and instead a mandatory provision is provided saying that the court shall grant specific relief. I know I'm repeating it to some extent, but that is in fact the thread which runs through the large part of the amendment. Now, there are certain judgments on this. The Delhi High Court has, in the judgment of Nishant Basoya versus High Court of Delhi, held that how can it be versus High Court of Delhi? There might be some error, but we'll check. The citation is there, which says that it is now mandatorily enforceable, and the provision new section 10 is interpreted. Thereafter, it is also held that this provision shall have retrospective effect even for pending suits. So even if there were contracts which were executed earlier, or the suits were pending prior to the amendment, but the suits are heard and tried after the coming into force of the Specific Relief Amendment Act of 2018, then the amended provisions will be applicable even to such suits. So there is a judgment of the Allahabad High Court which says it will apply to pending cases, and there is also a judgment of the Delhi High Court in the case of Jindal Saw versus Aperam Stainless Steel, which says the same thing. So, and that Delhi High Court has relied upon a Supreme Court judgment which says that the law of specific relief is in essence a law of procedure, and amendments to procedural law are generally retrospective. So that is the principle. So section 10, as you see, was one of the first provisions which removed the discretion and made even for movable goods or all categories of contracts enforceable. And consequent to the amendment in section 10, a lot other clauses of a lot other provisions of the Specific Relief Act were also amended. To this effect, you will see section 11 amendment, which says that cases in which specific performance concern connected with trust, again you will see that the discretion part is deleted and it is made mandatory and it is made a matter of right, and it says the contract shall be enforced. So as I said, some of these amendments are a consequence of the amendment to section 10 and to bring about the same flavor at different places. Now see section 14. Section 14 is again a provision. As I said, section 10 generally provide that contracts could be enforced. But section 14 provided certain category of cases where the contract cannot be enforced, or the courts would usually not enforce that contract. Now, if you see, the following contracts cannot be specifically enforced. Now, first A was a contract for non-performance of which compensation in money is an adequate relief. So you may forget the green portion right now. Let us just see the red portions, the deleted portion. So again, once again, this part is deleted. Then there were situations that the court felt that if the contract ran into many details and which was dependent on personal qualification or volition of parties, or of such a nature that the court cannot enforce the performance, then the court may not give a performance of such a contract. And then there were certain other clauses below which were, an exception to clauses 1A, C, and D. Now, a large number of these clauses got deleted, and therefore these exceptions also got deleted immediately, because if the main provision didn't remain, then the exception did not remain. So now there are only 2 or 3 categories of cases where the statute provides that specific performance cannot be granted. One is where you have obtained substituted performance. So it's very simple. If you have already gone and got your performance from someone else for this contract, then you cannot go back to the original party and say, now you also give me the performance of the same contract. You can, claim your damages from him. You can claim the difference from him and all that. But you surely cannot go back to that very party and say, now you again perform it. So there cannot be double performance of the same contract. Then original clause D, we said that a continuous supervision by the court may be required. Such contract need not be performed. That is continued because the court is not going to be a supervisor day to day of, identifying whether the contract is performed, not performed, and every day take action in contempt. Then even otherwise, this personal qualification part is molded and introduced as a separate provision. And this earlier clause C, we said that the contract, which is in its very nature determinable, is now renumbered and put in as clause D. So basically, as I said, this provision also reduces the discretion of a court, or reduces the power of the court to grant specific relief. The purpose is, if you have entered into a contract, then the statute now believes that the party should be held to the bargain and should be asked to perform his part of the commitments, not just compensate the party by way of damages later on. So the entire scheme is towards enforcing contracts. So just have a look at these deleted clauses, and there is also an analysis of this below to some extent. So, this is a very important provision because this again has deleted the provision relating to money. Now, one more provision which has been added now is section 14A. Now, section 14A actually is nothing very exceptional which is added. Such powers were in a way always with the court. 14A now empowers the court to appoint an expert. It says that without prejudice to the generality of the provisions in the Civil Procedure Code, where the court thinks that it requires any special opinion, expert opinion, to assist it on any specific issue involved in the suit, it may engage one or more experts and direct the expert to report to the court. And the court may also require the parties to give relevant information to the expert, or the report of the expert may be made a part of the record of the suit, and the parties may also be permitted to cross-examine such an expert. And the cost and expenses of such an expert shall be payable by the parties in such proportion and within such time as the court may direct. Actually, there were similar powers in the Civil Procedure Code regarding appointment of a commissioner for taking accounts, a commissioner for site inspection, and various other provisions in the CPC were there. But most of them emanated on an application being made by the parties. This provision now empowers the court to appoint an expert on any specific issue in this suit. So a wide discretion is given on the court on its own volition also to appoint an expert. Now, to give you all an example, a ready example of this, if you all have attended any hearings in court relating to redevelopment or development contracts where a flat purchasers have filed a suit saying the developer has not completed my building and I am not getting my flat, very often the court has been appointing architects and experts to go and identify how much is the work left, how much is the cost which is required for completion of such work, and how much time is required to complete such work. So that can immediately be considered as an invocation of this power. So the courts may not have not always been doing that by invoking this power, but this is a provision which now expressly empowers the court to do so. So in order to enforce the performance of, say, a development agreement or a flat purchase agreement, the court appoints an expert as an architect, as a person who is expert in the field of development to identify the balance work, the extent of cost, and various other aspects. Or say if there's a dispute that a building is dilapidated or not, the court can appoint an independent architect to go and give a report as to what is the state of the building. So these are all now provisions which are specifically introduced in the Specific Relief Act. Because, at times when we make these applications, we are not conscious that if the judge were to ask us, under which provision have you made this application? Very often we do it because you hear everyone do it. You see everyone do it. But it is important that most often for every prayer of yours that you make in an application, you can relate it to some provision, some entitlement under some statute. And the knowledge of these provisions would really help in that regard. Then there are two provisions which are added, which is 15FA and section 19CA. These are mainly provisions which are introduced because now there are limited liability partnerships. So earlier there were provisions which said that if one company has amalgamated with another company, then the contracts executed by that company could be enforced with the new company which arises out of the amalgamation. Now, as you all are aware, the limited liability partnerships are also in effect a separate entity, but there were no such provisions for a limited liability partnership. So in respect of a limited liability partnership, now these provisions are added to say that if one limited liability partnership has merged or amalgamated with another limited liability partnership, then all the contracts which were executed by such a limited liability partnership can be enforced by or against that entity, by the new entity to which it is amalgamated. So if a limited liability partnership entered into a contract and thereafter it merged with another limited liability partnership, then all the contracts executed by or against that original limited liability partnership can now be enforced by or against the new entity which is now created as a result of the amalgamation. So these are two procedural provisions, but importantly, there is also a provision in the original Specific Relief Act, which provided that pre-incorporation contracts executed by a company can be enforced against the company in certain circumstances, which is, I think, that aspect has not been introduced for a limited liability partnership. Though, as I said, it's not an exhaustive code, so it may still be open to arguing that that can still be done in a general law. But that's an aspect which is not covered in the amendment. There is a very important amendment in section A, C, and the explanation there too. The earlier provisions were that it was mandatory for a party to aver and prove that he was ready and willing to perform the contract. Now, at times, there were arguments of hyper-technicality that this word readiness and willingness is not expressly pleaded, that the party has not expressly stated in the plaint that he is ready and willing to perform, his part of the contract, the plaintiff, that is the party seeking performance, has not pleaded this, as a result of which he cannot be allowed to lead evidence on that. And without a proof of readiness and willingness, which is, in the absence of a pleading cannot be done, the suit must fail. Though the Supreme Court in various judgments did say that the exact use of these words readiness and willingness is not something which needs to be used in so many words, but if it is apparent from the conduct of the party as made out in the pleading, then also it is sufficient. Now, what is readiness and willingness? Readiness is a situation that you have the financial wherewithal and the means to complete the contract. And willingness is your mindset, whether you're desirous of completing it or not. So you should have both the desire to complete it and the means to complete it. So in order to avoid such technicalities being raised to defeat the argument of, defeat a claim of specific performance, Section 16A and C of the Specific Relief Act have been amended, where the word aver and prove have been substituted with the word fails to prove. So even if there is no express averment about your readiness and willingness, you can prove that he has performed or has always been ready and willing to perform the essential terms of the contract, which are to be performed by him. He must, of course, before he gets specific performance, make out that he was and he continues to be ready and willing. So it is supposed to be an unblemished readiness and willingness. From the date of the contract till the date of the decree, there should have been no hesitation, no disinclination on the part of the plaintiff to perform the contract. And at any stage, if it is shown that either he was not ready or he was not willing, then this claim for performance cannot be granted. That position still stands. Only the requirement of an express averment is now done away with. The next important provision, as I said, is the provision relating to substituted performance. So Section 20 is a provision which was originally a provision which provided for a discretion as for decreeing specific performance. And that provision regarding the discretion has been completely deleted, and instead a provision has now been introduced regarding substituted performance. So if you all will see this note, you all will find just about everything in this. Yeah, just see the section 20 originally how it opened. Discretion as to decreeing specific performance. The jurisdiction to decree specific performance is discretionary, and the court is not bound to grant such relief merely because it is lawful to do so. But the discretion of the court is not arbitrary, but sound and reasonable, guided by judicial principles and capable of correction by a court of appeal. So there was a discretion, and how the court should exercise discretion, etc. Various circumstances were set out in the other parts of Section 20. So now, since, as I've been repeatedly saying, the discretion part is taken away, the entirety of the original Section 20 is effectively deleted, and now instead a completely different provision regarding substituted performance is now introduced, and which says that except where otherwise agreed by the parties, where the contract is broken due to non-performance or promise by any party, the party who suffers such breach shall have the option of substituted performance through a third party or by his own agency, and recover the expenses and other costs actually incurred, spent, or suffered by him from the party committing such breach. So let's take a simple example, since it applies to Bombay a lot. A society gives a contract to a developer to carry out the renovation work of his building, and the developer fails to do so. It is open to the society to get it done by some other developer and then recover the entire cost of development from the original developer whom he had appointed. So therefore, this is now a statutory recognition of substituted performance, that you can engage a third party, and from the third party, you can recover the costs and expenses. So earlier in many contracts, there were provisions regarding risk purchase or risk and cost consequences which provided for similar things. Now, this is the norm, irrespective of whether the contract says it or not. This section 20 provides that you can get a substituted service, but importantly, if you see the opening part says, except as agreed upon by the parties. So you can opt out of section 20 in a contract, or if the contract provides for a scheme different than that of the act, then to that extent the contract will override the provisions of section 20 of the act. So the provisions of section 20 of the act are subservient to the contractual provisions. Now, there are provisions as to before doing substituted service, you must give them 30 days notice to the defaulting parties, give him an opportunity to rectify it, and only if he fails to do that, that you can get it performed by a third party. There is that in addition to that also, you can claim damages and compensation from the party in breach. So apart from the cost, suppose the delay has caused you some further problems and has caused you further damage, you can claim that all from the original defaulting party. So this again, as you see, clause 3 says that once you have got a performance from a party, from another party, you cannot get the same performance twice over from the original party. So this is an important provision which is added, that you can go to a third party, get it performed, and you can have this substituted performance. Now it is important, this Mr. Nafade, who's done this note, has done a great job of analyzing the portions which are deleted in section 20 regarding the discretion and how the discretion can be exercised with various other provisions or similar provisions of the US code and the Uniform Commercial Code followed in the United States and other international norms, to say that Indian law has now become much more stricter, and the various other statutes, while they continue a little discretion in the code, now all that in Indian statute, those provisions are removed. So a lot of the original discretionary conditions which were set out in the Specific Relief Act, which are now been deleted, continue in the legislation of various other courts and other legal systems. So please have a look at these charts and a comparative note. It is very helpful, in fact, which gives you an idea. Also, the provisions of section 20 can also be related to some extent to section 73 of the Contract Act, which is in relation to breach, compensation for breach. And some of the illustrations which are set out in section 73 of the Contract Act, which if you see, these are the illustrations, that a contract to repair B's house in certain manner, and if A contracts to repair B's house in a certain manner and receives payment in advance, A repairs the house but not according to the contract, B is entitled to recover from A the cost of making the repairs conform to the contract. So this is exactly what now the illustration, some of these illustrations are now put in the form of a statutory provisions in the Specific Relief Act. To some extent, there is an overlap of section 73 and section 20. And in fact, they have to be read in a complementary manner. Then the next line of amendments which are relevant are, as I said, provisions relating to infrastructure projects. So now there is an embargo under section 20A, which says that no injunction shall be granted by a court in a suit under this act involving a contract relating to an infrastructure project specified in the schedule. So it is open to the government to notify certain kind of infrastructure projects, and in relation to those infrastructure projects, the court cannot grant an injunction if that injunction has the effect of delaying the project. Now, let me make it clear that this does not take away the power of a writ court under Article 226 of the Constitution of India. So this will be the court can take that into account, but there is nothing which can be an absolute embargo. The Specific Relief Act cannot be an absolute embargo to the exercise of power by the court under Article 226 of the Constitution of India. This is now a new provision in relation to infrastructure projects, and it provides that the government can keep adding different kind of infrastructure projects or specific infrastructure projects to a notification which can be amended from time to time, and the government can keep issuing fresh notifications, adding to the schedule of infrastructure projects, in respect of which no injunction can be granted by the court, where the effect of such injunction is to impede the delay in the progress of completion of the project. This was introduced mainly because it was found that in lot of infrastructure projects, because of some civil disputes, some injunctions were granted, and they had a serious effect on the completion of the project, and that affected the public at large. This provision also contemplates that the state governments, in consultation with the Chief Justice of the High Court, shall designate one or more civil courts as special courts, which will try suits under the Specific Relief Act in respect of infrastructure projects. So now, since they have said that there shall be no injunction, they said, let's dispose of these suits properly. Now, there are so many legislations which have come, which keep saying that form special courts. So special courts are formed, but most of these provisions remain only on the paper. Nothing is effectively implemented. The Specific Relief Act now contemplates that such a suit involving an infrastructure project shall be disposed of in a period of 12 months from the service of the summons, and that such a period can be extended by a period not exceeding 6 months. So it contemplates that with an outer limit of 18 months, this suit should be disposed of in relation to infrastructure projects. I don't think this has been, though there is a statutory provision to this effect, I don't see any effective court giving effect to these provisions. But there is a problem which in the long run will arise, because this section now says that such a suit should be disposed of in 12 months. And the period of 12 months can be extended by a period not exceeding 6 months. So what happens to the status of the suit after 18 months? If the suit is not disposed of after 18 months, is the court denuded of its power to consider the suit? Or is this an embargo on further consideration of the suit? Now, because the word is not exceeding 6 months, these are issues which will be considered in appropriate judgments. I have not come across any judgments. It is important that in similar provisions, the court had read them as directory and not mandatory, and maybe that will be the similar fate of this provision, and which, as I said, leads to the provision remaining only on paper and nothing effective gets done. One more provision which is important is section 21(1), which is the power to award compensation in certain cases. Now, this is an important provision, and I think this will lead to a whole lot of complications in future. The original provision was that in a suit for specific performance of a contract, the plaintiff may also claim compensation for this breach, either in addition to or in substitution of such performance. So when you claim specific performance in a suit for specific performance, we usually frame prayers saying specifically performs. If in the alternative you find that specific performance cannot or ought not to be granted, in the alternative to performance, give me damages. And if in addition to specific performance, also give me damages, because even if he performs it now, I've already suffered damages. That performance will not be enough. In addition to that, give me damages. But now, since it is provided that a specific performance must be granted, the court has removed the words in substitution of the legislature has removed the word in substitution of, and also only retained the word addition to such performance, because the case as believed was that earlier courts had a discretion to grant or not to grant specific performance. It is in that circumstances that a power to grant specific performance in substitution of a contract was required. Now that there is no more discretion in the court, then why do you require a provision for grant of damages in substitution of such performance? You can only claim damages in addition to such performance. Now, there are still certain categories of cases where specific performance can be rejected. Suppose it says that it depends on the personal qualification of a person. Now, suppose I engage a painter to paints a painting for me. He refuses to paint. Maybe I cannot compel him to paint it for me. But instead of getting this performance, instead of that performance, I should get damages. So originally we used to frame a suit which said that grant me specific performance. If specific performance cannot be granted, then damages can be granted. There used to be another prayer that even if specific performance is granted, in addition to that, grant me damages. But now that this word's substitution of can you make that alternate prayer is an issue which will have to be seen. But I would believe that though this provision reads like this, I think it will have to be read in light of the scheme of the entire act and the Amendment Act to read that the idea of this provision is only to clarify that the court no longer has a discretion, and therefore the word substitution is removed. So therefore this is a provision, as I said, it may lead to some arguments and complications in future. As lawyers, it is our job to find these kind of complications, because someday you will be arguing for, someday you will be arguing against. So it's important for you to keep a note of this, so that if at times even the other side raises such an objection, you are ready to answer that. Then there are a whole lot of other provisions which are not very relevant and not very consequential, which you all can have a look at. Now, one important aspect is that though the provisions relating to specific performance have been amended, the provisions regarding the grant of a mandatory injunction and various other provisions relating to injunctions are not amended. So though the discretion aspect is taken away from the provisions relating to specific performance, the discretion still continues in the context of a mandatory injunction. So very often, the specific performance also entails requiring and positive directions to a party to do something. Now, that discretion still remains in the court and say whether or not the discretion can be granted. Now, that's something which will lead to, again, complications, as I said, because though specific performance is not left discretionary, injunctions are left discretionary. So where mandatory injunctions are required to enforce a contract, can it be said that the court has a discretion whether or not to grant such an injunction? Because if the court has a discretion not to grant that injunction, then that will defeat those amendments which says that grant of a specific performance is no longer discretionary. So I guess these provisions have to be read holistically, and where a mandatory injunction is being granted in aid of specific performance, then maybe it can be said that this discretion will not be exercised. But maybe if there are situations, very many situations, where a mandatory order or mandatory injunction can be sought, dehorse a specific performance, in which case it can be said that the discretion continues. So I have listed out some incongruity between the amendment and the continuing provisions, which also is largely in relation to the grant of injunctions. This is something which ought to be considered and seen. Now just see, an injunction cannot be granted when an equally efficacious relief can be granted can be obtained by any other usual mode of proceedings. Now there was a similar provision for specific performance also. Though that provision is deleted, it is this provision in relation to the injunction is not deleted. So that might lead to some incongruity in the different provisions. So this broadly, according to me, was the scheme of the amendments to the Specific Relief Act. Let me see some of the questions which have come in. What is the removal of the aver, section 16C means? So this part I have already, I think, covered to tell you all that, averment means that express pleading is not required. Are there any other contracts other than construction contracts which provide for substituted performance? Any contract, even if a supply contract, you can go and purchase it from someone else and claim the difference from that party. That was always there. But, suppose there are 4 or 5 items only in the market. You can go and buy the same thing from someone else. Or there are so many other the substituted performance contract is not restricted only to construction contract. That's only a readily available example. It can be applied to any kind of contract, provided substituted performance is possible. So you should be in a position to go and get it from somewhere else, get it performed by someone else. Remedy of alternatively, in case of non-grant of specific relief, asking for return of advance money is under which section? I think I just showed you all that in case of not granting interim relief, that is the aspect I think I dealt with right now, which said that though this provision substitution of is deleted, but I would still believe that you can still claim in the alternative specific performance in situations where specific performance cannot be granted, the contract though valid, but because of certain situations, because the situation is such that it cannot be granted. As I said, suppose you sue for a specific performance of a sale of a painting, and you say, see, there is a painting of M.F. Hussain, which this gentleman has. He had promised to sell it to me. Ask him to hand over this painting to me. I'm willing to pay him the money. When the suit comes up for hearing, you come to know that the painting got destroyed in fire. Now the painting can no longer be given to you, but you can always claim damages in that regard, because that is not where a court is not giving you performance at its discretion. That is where, despite you otherwise having been entitled to performance, the court does not have the power to grant that performance. I'm sure that alternative claim for damages in such a situation would not be barred. What about such infrastructure projects which cause grave problem like environmental problem? So one side courts can't grant injunction. So in such cases, how would the court strike the balance between the right of the party and the right of the public at large? Yes, this is a situation very often in infrastructure projects. Therefore, the remedy of writ is invoked, and whereas environmental issues and other issues, you always have a right to invoke the writ remedy and espouse your right to life under Article 21. No specific relief can override the no specific relief act can override your fundamental rights under the Constitution of India, and the powers of the court under 226 are always there. The striking of balance is sought to be achieved by the legislature by directing that the infrastructure should be disposed of within a period of 12 months. But as I said, that is only a wishful thinking. I don't think that can be achieved very easily considering our current situation. In the case of the nature of property has substantially changed after entering into contract for open plot of land, such as construction of building thereon. In the case of a contract was for open plot of land, in such case, can the court award damages in such situation? Any case law to that effect? That is what I precisely dealt with. And I said, if it is not possible, then it's always open for you to say that it is he who led to I not getting performance, so grant me damages. In what cases can a landlord file a suit under Section 6 of the Specific Relief Act instead of recovery of possession under the Maharashtra Rent Control Act? That will be only in situations where he is not seeking recovery of possession from his tenant. If his tenant has been wrongfully dispossessed, then the landlord can also go and seek possession from the person occupying who has dispossessed his tenant wrongfully. So I don't think Section 6 is an ordinary remedy for a landlord-tenant relationship. It's not so. But if the landlord has wrongfully dispossessed his tenant, then the law always was that the tenant has always a right to go within 6 months under a claim of Section 6 suit. I hope I made myself clear that for a landlord to file a suit under Section 6, it is only where his tenant has been illegally dispossessed by someone else. But say a landlord himself has gone and forcibly dispossessed his tenant can always file a suit under Section 6 against the landlord, irrespective of the remedy under the Maharashtra Rent Control Act. Just to clarify, in specific performance suit, can there be no longer alternative relief for payment of damages? No, as I said, I would believe it can still be done and it should be done. It cannot be that after the court finds that specific performance cannot be granted to you for reasons beyond the control of the court, you would have to file a separate suit for damages. I don't think that can be the way of interpreting the amendment to the Act. And the amendment, that's why I said, must be read in accordance with the entire scheme of the amendment to say that the deletion of the word in substitution of should be really because the court no longer has a discretion. Just to clarify, court grants specific performance of a contract which has several steps to be performed by each party before the contract is fulfilled. Of course, it can be done. But if it is a situation where it is not just possible for a court to monitor there are such details, then it cannot be done. Can you give us an example of a contract which is determinable in nature of which specific performance cannot be granted? A contract having a clause which says that by 2 months notice the contract can be terminated. So generally the courts have read such contracts by its very nature as terminable, because if the party could have given notice of that 2 months and terminated, then by very nature the contract is terminable. Can specific performance be granted in arbitration by arbitral tribunal? Certainly it can. There is a specific judgment of to this effect. I think it is in the, I forget the name of the case, but there is a Supreme Court judgment to this effect. Can the court condone the delay in filing a suit under section 6 of the suit beyond 6 months? I don't think the court has any such power. It's an absolute power of limitation. Can service agreements be specifically performed like contractor agreement? Can it be argued that it is personal qualification and requires supervision of the court, and hence it cannot be specifically enforced? I mean, there is no embargo as such, but that will all depend on the nature of the contract, the nature of the work assigned, how much of an supervision it is required, etc. Sir, in case of purchase of immovable property, vendor has taken part. These are case related. An agreement is to sell between A and B. If B sells the property to C, can A sue for specific performance? What is the remedy? Of course, he can sue provided the C had knowledge of his agreement between A and B. He can, this is clear case law on this. If you have a look at that and the provisions of the Specific Relief Act, you would get an answer. What is a better remedy for a tenant, Maharashtra Rent Control Act or Section 6? I have answered that if the tenant has been dispossessed forcefully by the landlord without getting a decree of eviction against him or without following the provisions of law, then a landlord can file a Section 6 suit in court. So there is, in Section 6 suit, there is a chance of the court immediately directing restoration of possession by way of a receiver or putting him back in possession. So to that extent, a Section 6 suit is a better remedy in court. I mean, but it depends on each circumstance. I don't think there can be an absolute situation as a lawyer to say it's always a better remedy. It depends on what are the facts of that case. So thank you so much. And that was a little overview of the amendments.